Okay, today we're talking about the federal court system, the judicial branch, and um, we'll kind of walk through um, the different parts of the judicial branch. So, obviously, most of you probably know there's two types of cases and that go through a judicial branch. One involves criminal law, and that's if you've committed a crime and you've violated a law, and so you go through the criminal justice system, which is kind of a separate system. It's all within the same court system, but you have prosecutors and criminal defense attorneys. Okay, that's one type of case. The other type of case involves civil law, and that's a dispute between two parties. The parties can be corporations, the parties can be a government and a citizen, but it's involving a civil matter, all right? Whether that's employment based on a statute or what have you. If it's not a crime, then it's going to be a civil lawsuit. Most cases are tried and resolved in state courts, okay, not federal courts. So um, the, the bulk of the work is done at the state court level. There's actually, in order to bring a case into federal court, there has to be a federal statute that allows that you're suing on, or there has to be a controversy between two people from different states, and the amount is large enough to justify going into federal court. Um, and so those kind of things are the types of cases that go into federal court. You don't just get to choose wherever you want to bring your case. Okay, the case has to have a connection to the court where you bring it to, and there's not as many federal laws to be sued on and to sue as there would be state laws. So the state law system is just a lot larger. Who participates in the judicial system? So you have litigants, right? These are the parties. Um, and so in a civil case, you have the plaintiff, that's the one bringing the lawsuit. Um, or in a criminal case, the state is the one that brings the lawsuit, or not the criminal charges. So you'll see state versus John Doe, right? That's how the criminal state of Iowa, state of South Dakota versus John Doe is how um, the plaintiff is actually the state where the crime took place, or if it's a federal crime, then it's the United States government, U.S. versus the defendant. So the defendant is the one being charged with crime or defending against the lawsuit. Defendants in a civil matter can then sue the plaintiff back, all right, in what's called a counterclaim. So sometimes your defendants then, if they've been sued by the plaintiff, they sue the plaintiff back, and we have a counterclaim. So the defendant is not only a defendant, but then also a plaintiff. And then the plaintiff, the original plaintiff, is not just a plaintiff, but also a defendant. So then the case is tried by a jury. You can waive that. Some cases can only be charged or can only be heard by a judge. But criminal cases, you have the right to trial by jury. And in certain other civil cases, there's rights to trials by jury as well. Standing. This is a kind of a not well understood point by the general public. What standing is I couldn't just sue um, in South Dakota for a violation of my civil rights, right? I'm not a resident of South Dakota, and so I don't have standing because something that I have is not in jeopardy when I bring that lawsuit. So, as a good example, a few years back there was a father who sued um, saying it was a violation of his First Amendment rights that his daughter had to say the Pledge of Allegiance to start school. And so got all the way up to the Supreme Court. The Supreme Court said, well, actually, you don't have standing because it's the daughter, not you, who's um, it's not your rights who's really being violated, right? So standing, and a lot of times standing can be a nice out for the court just to say, well, we don't want to decide this because um, this person doesn't have a judicial interest. But it's also a very important concept because if you were in a car accident, um, I say, well, I'm gonna if you don't sue, I'll sue on your behalf, and so then I sue, um, you know, John Doe who hit you with his car. I don't have standing because I wasn't the one injured. Okay, you'd have to do some more elaborate things and transfer your ownership of that claim to me before I would have standing. But just me going in and suing someone I don't have standing, meaning I can't bring a lawsuit. Justiciable disputes, it has to be capable of being settled, right? Um, which falls first, or which does a tree make a sound when it falls in the forest? That's not a dispute that can be settled um, as a matter of law. There's other, that's an extreme example, but that's what the concept means. It has to be something that the court can actually deal with and provide a remedy for, or not. So it's got to be something the court can actually decide, and not something that's impossible to decide. Who participates in the judicial system? Well, you might not think interest groups have an impact in the judicial system, or we normally don't think of interest groups as being part of the judicial system, and they're not directly, right? But there is an ability, even if I just talked about standing, how you're not in the case and all that kind of stuff. Well, you can't bring the lawsuit. But once the lawsuit's been brought and it's on appeal, but only after it's on appeal, not when it's at the district court level. When it's on appeal to the Supreme Court or an appellate court, interest groups can ask permission from the court to file briefs supporting one side or another of an issue. And briefs are a long, um, basically persuasive paper trying to argue to the court that one side or the other should win. And so interest groups will often track cases, and for a really important case, they will ask permission, and then they will a number of groups, or maybe a few groups, will file what are called amicus briefs, amicus curiae. You see there in the PowerPoint slide, and so they'll file these briefs seeking to convince the court that even though they're not directly involved in the case, the court should still go the direction that they feel is important because of this and this reason laid out in the brief. And some of those briefs can have an impact, and some of them, on bigger cases, there can be up to 200 to 500 briefs filed by parties that aren't directly related in the case. And at that point, you're just kind of a lot of noise. I'm not sure that those briefs really make a whole lot of difference after a certain number of them. Okay, class actions, people can band together. So if I wanted to sue Toyota or somebody because my airbag didn't function right, but I'm concerned about Toyota's money to throw at lawyers and drag things out. What if I all band together with everybody else who's had a bad airbag experience? If we all join together, then that's much more powerful now. A lot of times the lawyers in the class action lawsuits then are able to, it's very lucrative for them to do that, because if they get a third of the big return, then that's a big chunk of change for them to work with. The Legal Services Corporation, so Iowa Legal Aid, there's legal aid societies that will provide legal services to the poor if you qualify under income restrictions. So they'll have you fill out a worksheet when you first get in the door to see if you qualify for their services, and then they will try to help you from there. And sometimes the lawyers, there's good lawyers there and there's bad lawyers, just like there is in every walk of life. So we mentioned this a little bit before. There's district courts, there's appellate courts, and Supreme Court. So a case, whether it's in federal court or federal law or it's in state court will always begin in the district court. Now, different states call these different things, but it's basically the lowest court, the first level that you start in. Okay, so the case has to be first heard, so you can't just file your lawsuit with the U.S. Supreme Court and get in there right away. You have to start at the bottom level. So you file in the district court, and then that's the court that hears the testimony. Appellate courts don't hear testimony. The district court hears testimony, decides what's true and what's not, decides the facts, and hears federal crimes, civil lawsuits, bankruptcy proceedings. This is federal district court. Reviews federal agencies, and then kind of admiralty, which means the law of the sea and naval kind of law. Appellate courts, so once the district court's made its decision, if one party wants to appeal, they appeal to courts of appeal. And there's different standards that the courts of appeal review in order to determine whether or not the district court's ruling is upheld. They don't have trials and they don't hear testimony, as I said before. Lawyers can make arguments based on their briefs, and so lawyers can stand before them, and so a panel of judges typically, and the lawyer makes arguments to the panel, and the panel decides from there. There's U.S. Courts of Appeal for the Federal Circuit, involving very specific things. If there was some kind of terrorism, it's usually in D.C., not the U.S. Supreme Court, but a specific court just and it's focused on doing the issues surrounding the federal government. And the appellate court is supposed to look at errors in procedure under differing standards depending on the type of the case. And so the appellate court sometimes is completely reviewing the case and looking at it new. Sometimes it's very narrowly focused on only clear errors that were made at the lower court. So those standards are important. And the reviewing common law. Common law refers to cases that have been decided. So when you talk about sources of law, you have statutes, those kind of things, but you also have all the cases that have come before, right? So if you have a very similar case that was decided by the same court in the same way the prior year, that's precedent, right? And being able to cite precedent is helpful. All of those cases, so cases from state or federal courts, that all makes up the common law. So this is how the courts are organized, right? Down here for federal courts, you have 91 district courts, and these are independent regulatory, like the Nuclear Regulatory Commission. So they hear appeals about nuclear power and stuff like that. So that's more of a bureaucracy kind of commission. So if you don't like the ruling that you get at the district court level, then you can appeal from the district court up to the Court of Appeals, right? These are military courts, those special courts up to the Court of Appeals for Federal Circuit that we were talking about. But this is where the main action happens. So if you don't like your ruling at the district court, you appeal it to the Court of Appeals for the circuit where you live, where the case was brought. And so then from there you can appeal to the U.S. Supreme Court, okay? U.S. Supreme Court can decide whether or not it's going to take your case. You have the right to appeal directly to them, so you always can go up to this level if you don't like what happened at the district court level. If you appeal up here to the Supreme Court can say no to your appeal, and so you only get to this point if the Supreme Court wants you to get to that point. If the Supreme Court says no, then the decision of the Court of Appeals will stand, okay? If they do take it up, then the Supreme Court reviews it according to those same standards. So here's the different circuits, right? So we're here in the 8th Circuit, which is a pretty broad circuit, right? The 9th Circuit is also quite huge, and is largely seen as probably the more liberal circuit in the country. California is there. A lot of the West Coast states are in the Ninth Circuit, usually seen as the more liberal circuit. The Fifth Circuit down in Texas is viewed as being more conservative. You've got Texas down there, so that's part of why you're doing that. Up here in the Northeast, New York pretty much has its own circuit because there's a lot of cases coming through there, given all the business and whatnot. And the Fourth Circuit is important too, since DC is part of there. And they're all important, right? Seventh Circuit's got Chicago, those kind of things. They're all important. That just shows you a map of the different circuits. So who's on the Supreme Court? Well, there's 9 justices on the Supreme Court. There's 1 Chief Justice and 8 Associate Justices. As I said before, you don't get to the Supreme Court unless it decides you can go there, because it gets to decide which cases it will hear. There's some things that can go directly to the U.S. Supreme Court. They're fairly rare. The vast majority of things are appellate decisions coming from lower courts, as we say there. Most of them are civil cases rather than criminal cases. So here's just a sampling of the 2000 term. So as I said, rarely are the cases of an original jurisdiction. If there's, some kind of, we'll look at that in a minute, but very rare. Civil actions from lower federal courts that made up a lot of the cases. Criminal cases, right? Civil actions, state criminal cases. And so if you don't in order to get from the state courts to the U.S. Supreme Court, you have to go all the way through the state court system. So you start at the state district court, state appellate court, state Supreme Court. You can appeal from the state Supreme Court decision to the U.S. Supreme Court, but it's got to involve a criminal case or some federal statute or something. And so the U.S. Supreme Court took a total of 81 cases in that term. And here's how those work again. Just a different chart. So it shows here the state route. So after you've appealed to the state Supreme Court, so if you made it to the South Dakota Supreme Court and you didn't like what you got, you could appeal it up to the U.S. Supreme Court from there. Cases involving foreign diplomats, cases between the United States and the state. So this is your original jurisdiction. This is what we were mentioning before. So if the case involves a foreign diplomat, it can go directly to the Supreme Court. If it's between the United States and a state, it goes directly to the Supreme Court. 2 or more states, between one state and the citizens of another state. And so, again, that's like state of South Dakota versus all the citizens of the state of Iowa. If that was the case, again, if you have the whole state involved, it can go directly to the Supreme Court between a state and a foreign country, so Alaska versus Russia or something. Those can all go to the Supreme Court. Those are all rare, right? The bulk of the action happens over here, so you go through the U.S. Courts of Appeal and up to the Supreme Court. So, as we talked about, the president gets to appoint all federal judges, right, of all the different levels of courts. So not just the U.S. Supreme Court, which that's the one that gets the most publicity, but then also the district courts, the federal district courts, federal courts of appeal. So the president gets to appoint all those different places. Now there's kind of an unwritten rule of senatorial courtesy, where the president's team of appointment people will look into the situation, come up with a name, but a judge is not confirmed if a senator of the president's party from the state where the nominee will serve opposes the nomination. Okay, so you kind of run it through the senator from that state if the president and the senator are of the same party. It has the effect of the president approving the Senate's choice, so to speak, by that measure. Now, what we'll talk about in a minute is there was a lot of filibustering even of these lower court judges, and they ended the filibuster rule just for the purpose of appointing judges and lower court nominees like that, because it became such a problem of trying to get people appointed. president has a much more influence on the Court of Appeals in the U.S. Supreme Court. He's not going to ask the senator whether he agrees with that or not. And again, it's only the senator of the same party. So, the Supreme Court president relies on the Attorney General and the Department of Justice to screen candidates who they think would be good potential candidates for the U.S. Supreme Court if there's a vacancy. So you only get to start that process, you only get to appoint somebody if there's a vacancy. So if there's a death, a resignation, those kind of things. 1 out of 5, so about 20% of nominees, so when you actually get to be nominated, 20% have not made it. Presidents with minority party support in the Senate will have more trouble because the Senate isn't who ultimately confirms it. And then the Chief Justice can be chosen from the existing justices, or the new justice can be chosen as the Chief Justice. So, for instance, our current Chief Justice is John Roberts. When Roberts came to the court, he immediately became a Chief Justice because Rehnquist, the former Chief Justice William Rehnquist passed away, so that left a vacancy. Roberts was appointed to that vacancy and immediately was named Chief Justice. Okay, so we're going to watch a couple confirmation hearings from some Supreme Court justices. And I want you to write down a couple things that appear to be the same about the judicial confirmation hearings and some things that appear to be different. We're going to be watching Robert Bork, and as you can tell, this one is from the 80s. John Roberts is going to be from the 2000s. And so, see if you can tell the differences between each confirmation hearing.
Hearing room in the Hart Building. And the senators' scripted opening statements that filled yesterday's session were replaced by pointed, case-specific questions. In fact, 30 seconds after he gavelled today's hearing into session, Chairman Specter went directly to the 1973 landmark abortion decision, Roe v. Wade, and whether it is considered settled law.
And I begin collaterally with the issue of stare decisis and the issue of precedence. Black's Law Dictionary defines stare decisis as let the decision stand, to adhere to precedents and not to unsettle things which are established.
Specter cited as an example Casey versus Planned Parenthood, the court's 1992 decision that for the most part upheld Roe.
In Casey, the key test on following precedents moved to the extent of reliance by the people on the precedent, and the Casey had this to say in a rather earthy way. People have ordered their thinking and living around Roe. To eliminate the issue of reliance, one would need to limit cognizable reliance to specific instances of sexual activity. For 2 decades of economic and social developments, people have organized intimate relationships in reliance on the availability of abortion in the event contraception should fail. That's the joint opinion, rather earthy in its context. Would you agree with that?
Well, Senator, the importance of settled expectations in the application of stare decisis is a very important consideration. That was emphasized in the Casey opinion, but also in other opinions outside that area of the law. The principles of stare decisis look at a number of factors. Settled expectations, one of them, as you mentioned, whether or not particular precedents have proven to be unworkable is another consideration on the other side. Whether the doctrinal bases of a decision have been eroded by subsequent developments. For example, if you have a case in which there are 3 precedents that lead and support that result, and in the intervening period 2 of them have been overruled, that may be a basis for reconsidering the prior precedent.
But there's no doctrinal basis erosion in Roe, is there,
Well,
Roberts?
I feel the need to stay away from a discussion of particular cases. I'm happy to discuss the principles of stare decisis.
The joint opinion then goes on after the statement as to sexual activity to come to the core issue about women being able to plan their lives. Quote, the joint opinion says, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Do you agree with that statement, Judge Roberts?
Well, yes, Senator, as a general proposition, but I do feel compelled to point out that I should not, based on the precedent of prior nominees, agree or disagree with particular decisions, and I'm reluctant to do that. That's one of the areas where I think the prior nominees have drawn the line when it comes to, do you agree with this case or do you agree with that case? And that's something that I'm going to have to draw the line in the same place.
Well, I'm not going to ask you whether you're going to vote to overrule Roe or sustain it, but we're talking here about the jurisprudence of the court and their reasoning. Let me come to another key phase of Casey, where the joint opinion says a, quote, terrible price would be paid for overruling Roe.
I do think that it is a jolt to the legal system when you overrule a precedent. Precedent plays an important role in promoting stability and even-handedness. It is not enough, and the court has emphasized this on several occasions, it is not enough that you may think the prior decision was wrongly decided. That really doesn't answer the question, it just poses the question. And you do look at these other factors, like settled expectations, like the legitimacy of the court, like whether a particular precedent is workable or not, whether a precedent has been eroded by subsequent developments. All of those factors go into the determination of whether to revisit a precedent under the principles of stare decisis.
Chairman Specter then moved to a broader discussion about the right to privacy and whether Judge Roberts believed it was protected by the Constitution.
Senator, I do. The right to privacy is protected under the Constitution in various ways. It's protected by the Fourth Amendment, which provides that the right of people to be secure in their persons, houses, effects, and papers is protected. It's protected under the First Amendment, dealing with prohibition on establishment of a religion and guarantee of free exercise. It protects privacy in matters of conscience. It was protected by the framers in areas that were of particular concern to them that may not seem so significant today. The Third Amendment, protecting their homes against the quartering of troops. And in addition, the court has, over with a series of decisions going back 80 years, has recognized that personal privacy is a component of the liberty protected by the Due Process Clause. The court has explained that the liberty protected is not limited to freedom from physical restraint, and that it's protected not simply procedurally, but as a substantive matter as well. And those decisions have sketched out over a period of 80 years certain aspects of privacy that are protected as part of the liberty in the Due Process Clause under the Constitution.
The committee's top Democrat, Patrick Leahy of Vermont, went next and challenged.
Porter went on to give Bork a chance to expand on what he said yesterday to the committee on what the Constitution has to say about a right to privacy.
We've now talked about contraception, homosexuality, sterility, I don't know where else, of sexual preference, sexual gratification. No telling where we'll get if we keep struggling along in this area. But those are important things. I don't even belittle that. But it's all been taken out of context, every bit of it. I don't think you had an appropriate time to respond on the issue of privacy. And especially with regard to the Griswold case and the Skinner case. And I guess I want to be sure, because there was a line of questioning yesterday which I gathered, and I think it was our chairman, and it was a good line of questioning. It was, well, if you don't embrace these things through some method, how are we going to get to that point? How do you protect? Well, I want to ask you if it is fair to say that you believe that privacy is protected under the Constitution, but that you just don't believe that there is a general and unspecified right that protects everything, including homosexual conduct, incest, whatever, and you mentioned that yesterday. Is that correct?
That's correct, Senator. I think the fact that I didn't get everything I wanted to say out was my fault, because I was trying to discuss with Senator Biden and others the constitutional problem. But I think it requires a fuller answer than that, and that is this. No civilized person wants to live in a society without a lot of privacy in it. And the framers, in fact, of the Constitution protected privacy in a variety of ways. The First Amendment protects free exercise of religion. The free speech provision of the First Amendment has been held to protect the privacy of membership lists and a person's associations in order to make the free speech right effective. The Fourth Amendment protects the individual's home and office from unreasonable searches and seizures, and usually requires a warrant. The Fifth Amendment has a right against self-incrimination. There's much more. There's a lot of privacy in the Constitution. Griswold, in which we were talking about a Connecticut statute which was unenforced against any individual except a birth control clinic. Griswold involved a Connecticut statute which banned the use of contraceptives. There was no, and Justice Douglas ended that opinion with a rather eloquent statement of how awful it would be to have the police pounding into the marital bedroom. And it would be awful, and it would never happen, because there is a Fourth Amendment. And the police, nobody ever tried to enforce that statute, but the police simply could not get into the bedroom without a warrant. And what magistrate's going to give the police a warrant to go into search for signs of use of contraceptives? I mean, it's a wholly bizarre and imaginary case. Now, let me say this.
Yield at that point, just for clarification.
Yes, sure.
If they had evidence that a crime was being committed.
How are they going to get evidence that a couple are using contraceptives? Wiretapping?
Wiretap.
You mean to say
they have
that,
a legal wiretap.
You mean to say that a magistrate is going to authorize a wiretap to find out if a couple is using contraceptives?
They couldn't
No,
they,
it's
the law?
unbelievable. Unbelievable.
No, I understand that, but under the law, Judge, could they not have? It was a crime, correct?
It was a crime on the statute books which was never prosecuted. Never.
Well, the fact that it wasn't prosecuted did not mean that it wasn't a crime, does it?
I have more to say about that, whether it was a crime or not.
Let's assume they were drug dealers. They were also accused of, there was evidence that they're involved in some other illegal activity, and there was a wiretap.
And they hear discussion of contraceptives?
Yeah.
Nobody is going to get a warrant for that, and no prosecution is going to be upheld for that. And I'd like to go on to that point, because
Thank you, sir.
I think the law was an utterly silly law. But my objection is simply to the undefined nature of what the court did there, and I've tried to illustrate that for you by asking you whether you would vote for a statute that said nothing more than that everybody has a right of privacy, and the court shall enforce it. I don't think you would.
Democratic Senator Dennis DeConcini, one of the few committee members still undecided on Bork's confirmation, spent several Senator Arlen Specter, who says he's undecided about confirmation, questioned Bork about his philosophy of original intent, that the Constitution ought to be strictly interpreted in the manner in which the framers intended. Specter said that philosophy doesn't appear to jibe with Bork's support of the famous 1954 Supreme Court decision striking down school segregation.
You said it was controversial, and I think it was that controversial because there was no legal underpinning for it.
Senator, I think there was, and let me say two things about it. One is that I have recently been told, I have never read the briefs in the Supreme Court, but I know some folks who have in Brown. And it begins to look as if there is historical argument that the framers of the 14th Amendment did not like segregation and may have intended to do away with it, but that as the black codes and the segregation didn't begin to come into the South until until the troops left the South, the northern troops left the South. And then later the Supreme Court changed. Plessy against Ferguson, after all, is an 1896 case, which is fairly long after the 14th Amendment. Plessy against Ferguson being the case that said separate but equal is all right. But passing that historical evidence, which I think casts some doubt on the flat assumption that the 14th Amendment really meant separate but equal, let me say this. They wrote a clause that doesn't say anything about separation. They wrote a clause that says equal protection of the laws. I think it may well be true, as you suggest, Senator, that they had an assumption, which they did not enact, but they had an assumption that equality could be achieved with separation. Over the years, it became clear that that assumption would not be borne out in reality, ever. Separation would never produce equality. I think when the background assumption proved false, it was entirely proper for the court to say, well, we will carry out the rule they wrote. And if they would have been a little surprised that it worked out this way, that's too bad. That's the rule they wrote, and they assumed something that is not true. And in that way, I don't think any damage is done. You can even look at it more severely. You could say, suppose they had written a clause that said, we want equality, and that can be achieved by separation, and we want that too. By 1954, it was perfectly apparent that you could not have both equality and separation. Now, the court has to violate one aspect or the other of that clause, as I have framed it hypothetically. It seems to me that the way the actual amendment was written, it was natural to choose the equality segment, and the court did so. I think it was proper constitutional law, and I think we're all better.
Okay, so that was the judicial confirmation hearings of Robert Bork and John Roberts. On your discussion groups, I want you to write those down and just a couple things that you think are the same about the two different hearings, and then what you think was different between the two different hearings, and then answer the question about whether you think both individuals were confirmed, or one or the other, whether or not you think they were both confirmed to be members of the U.S. Supreme Court. Not to give up too much of the answer here, this is a list of the unsuccessful Supreme Court nominees since 1900. And so there are people that are nominated to be on the Supreme Court that don't make it. And here's a list of those different ones. The most recent was Harriet Miers back in 2005 by George W. Bush. And a lot of the attack on Harriet Miers was that she had gone to law school at SMU, which was obviously not an Ivy League school. She hadn't been a judge, and many in conservative circles felt like she may not have the academic background to really make a difference on the court, which was unfortunate. She had been in the White House counsel, so she was George W. Bush's kind of personal lawyer at the White House. And so, unfortunately, though, Ms. Miers was not viewed as being a strong candidate for the position, so she then eventually withdrew her nomination herself. So, the first nomination, as we said before, William Rehnquist had passed away. So then George W. Bush nominates John Roberts, who you saw the confirmations hearings. Roberts was just a very eloquent speaker, as you can see in the video we watched. And he was basically a slam dunk nominee, both Democrats and Republicans, even though Roberts had a more conservative history. Roberts was viewed as kind of an easy confirm. Then we get to George W. Bush's second nomination for Sandra Day O'Connor, and this is Harriet Miers. So Sandra Day O'Connor, along with Ruth Bader Ginsburg, were the only women on the court at the time. And so when Sandra Day O'Connor, who was the first ever female justice, stepped down and resigned to kind of take care of her ailing husband, George W. Bush thought, well, let's appoint another female justice, and sought to appoint Harriet Miers, but as we said before, it was roundly criticized, so Miers withdrew, and Justice Alito was then nominated and confirmed. And Justice Alito had a very conservative background as well, and he was confirmed following his hearings. President Obama has been able to name 2 to the U.S. Supreme Court, and so when Justice O'Connor stepped down, it left Ruth Bader Ginsburg as the only female justice on the Supreme Court. And so then President Obama has appointed 2 female justices to the Supreme Court. And Sonia Sotomayor just has a great story and great background. She's the first Hispanic justice on the bench. Former prosecutor, had a distinguished career. Served as an appellate judge on the D.C. circuit, so they get a lot of the action from a federal circuit there in D.C. And just a great story where she is, through hard work and her own talent, kind of risen up from some humble beginnings and those kind of things. Elena Kagan, just an excellent, bubbly personality. And prior to serving as a justice on the Supreme Court, she had been in the White House counsel's office. So similar to what Harriet Miers had been for George W. Bush, Elena Kagan had served in President Obama's White House as his White House counsel. And so those have been the 2 nominees that have been confirmed, and the appointments during President Obama's term as president. So what are the backgrounds of the judges? Generally, they've been white males. Usually, it's good to pick lawyers, obviously, with a background in the law, and often there's some political experience. Usually, the presidents are looking for people of the same party with some of the similar conservative rulings in the past. But at the same time, there's no guarantee at how that justice is going to vote. So there have been justices appointed who people assumed were going to be more conservative or more liberal. When they got onto the bench, they acted differently, right? They ended up being more liberal than anticipated, and so then that's caused a lot of more scrutiny at the confirmation hearings to try and figure out how this person is really going to vote. So here's some of the backgrounds, just some statistics on the appointments that they've made, not only to the appeals court, but then also to the district court by Clinton, Bush, Reagan, and Carter. We look at the different kind of backgrounds that they would have had. Here's our current list of Supreme Court justices and who appointed them in the year of the confirmation and all that kind of stuff. And so, several of these folks, Ruth Bader Ginsburg doesn't have the greatest of health right now. Anthony Scalia is getting up there as well. But the rest of these folks are in fairly good health. John Roberts will probably be a Chief Justice for quite a while, as you can see. He's one of the younger justices, and just got onto the court, so he will be Chief Justice for quite a while unless something bad happens to him. Here's how the court takes on a case. So, as I mentioned before, if the Supreme Court doesn't take a case, then the Court of Appeals ruling just stands. So excuse me, the federal courts and the state courts, usually there's 7,500 cases that are submitted for review by the U.S. Supreme Court on an annual basis. So every year, 7,500 cases. And then the justices will discuss the different cases, and their clerks will help kind of screen the cases to see which ones appear to have the most impact or need to be decided because of the importance. And 98% of the 7,500 cases are denied. So you don't have a real great shot at moving up the ladder here. Okay, but if you get 4 votes from justices saying they want to hear that case, then it will be placed on the docket. Okay, so rule of 4, you need 4 of the 9 justices to think your case is important in order to get it on the court's docket. So once the court chooses to hear that case, it will issue a writ of certiorari, and that case will then become placed on the U.S. Supreme Court's docket. And as we said, your special case if you make it through that process. So once the case is on the docket, and as we talked about before, briefs, which are long, persuasive arguments, kind of policy papers, and trying to convince the court to choose your side, those are submitted by both sides. Any amicus briefs by outside third parties who have been accepted to write briefs are submitted. Then we get to oral argument, which is where you stand up before the justices and make your argument, and that's what you see a lot of, kind of portrayed, where you're up in front of the 9 people and they're firing questions at you, and you're trying the best to do your answers and present your evidence. Once the oral argument is over, the case is submitted to conference where it's discussed between the justices. Votes are taken, an initial vote. Opinion writing is assigned, so the Chief Justice decides who's going to write the majority opinion and who's going to write the minority opinion. If the Chief Justice isn't in the majority, then the most senior justice who is in the majority decides who's going to write the opinion, which of the justices is going to write the opinion. Any dissenting opinions or concurring opinions. A concurring opinion means that you agree with them, but just for different reasons. A dissenting opinion means that you don't agree, and here's the reason you don't agree, right? You can have multiple consents, multiple concurrences. So you can concur without joining the majority opinion. There's all kinds of ways that the justices can distinguish themselves, right? Once that's all done, then the opinions are drafted and circulated for comment by the other justices. Once that process is done, the decision is announced. Okay. Oral arguments, 30 minutes for each side in front of the court. We talked about concurring and dissenting opinions, and you're seeking to reason and make a persuasive argument on why your side should win. This is another, again, we saw some of these terms before. So dissenting opinions, justices who oppose the majority, those who support the majority but stress a different reason. And then you saw stare decisis in your video, which is basically upholding the rule of precedent, right? So precedent means the cases that have been decided. We want to use the cases that have been decided before and say we want to make decisions in line with those. Not always, right? You can break from precedent, decide the old precedent was bad, but prior cases ruled in that manner provides good instruction for judges to go forward with. And original intent, you also saw that pop up, the idea that the Constitution should be viewed according to the original intent of the framers, right? So it's original intent kind of versus living Constitution. The living Constitution mentality says, well, the framers were back in the 1780s, and so now in modern times we don't quarter troops in houses, we don't deal with a lot of stuff they dealt with. So when writing our opinions about the controversial topics of our day, we shouldn't go back and look at how people in the 18th century thought about those issues, because our society is different, right? The original intent, people would fire back and say, yeah, but the laws that were passed then in the 1780s, which are still in effect today, those were intended to function a certain way, and until those laws are changed or amended or something like that, that's the law that's on the books. So you need to enforce that law as written, as it was believed to happen. You saw a little bit of a difficulty in doing that in the Bork confirmation thing. When we're talking about, well, if the original intent of the 14th Amendment was kind of separate but equal, that assumption didn't bear out, and so then the court, in Bork's opinion and everybody else's opinion, but rightfully in Brown versus Board of Education, overturned segregation because it was a terrible idea and had not worked out at all. Implementing court decisions. So one of the big challenges for the court is, yeah, it can make opinions and make decisions, but it's completely reliant on other parts of the government, whether it's the executive branch or the Congress, to carry out their decisions. So you might say, all right, well, segregation needs to end, right? Well, it's not like the Supreme Court has a police force to go out there and start saying, all right, segregation is over, right? It needs other parts of the government to actually get the National Guard into the South and allow the black students to enter into the school, which is what we saw a lot initially when the Brown decision happened, right? In Little Rock, Arkansas, you're having to have police escorts for African Americans into the white schools because, again, that was people at that time in that area of the country did not like the idea of desegregation, right? But the point of all that is the court itself doesn't have the power or the police force or the boots on the ground to really enforce any of the decisions it's making, which is a challenge for the court, because regardless of the decisions, if other people are carrying out the decisions, they might choose to do so in a way that is in keeping with what the court intended. So there's different populations that look at Supreme Court opinions, right? So there's the interpreting population, who are lawyers, scholars, academics. They want to understand the decision. What does it mean, right? The implementing population, these are the boots on the ground, the executive branch, the police, whoever it is. These people are the ones that need to actually implement the decision. Sometimes they disagree with that decision, which can, like I mentioned before, can be a challenge for the court. Consumer population, these are the people who would be affected by the decision. So some just kind of the history of the Supreme Court. So John Marshall was kind of the first Chief Justice who really made the court look like it does today. Now, not perfectly, obviously, but really started to bring power and legitimacy to the Supreme Court. So in Marbury versus Madison, established the principle of judicial review, that the courts will determine the constitutionality of the acts of Congress, right? Keeping in mind that if something is constitutional and the Supreme Court gets to say that, then that's a very powerful tool to use. And Marshall established that whole power, right? The 9 old men refers to the challenges that I mentioned before that Franklin Roosevelt had with his New Deal stuff, because the 9 old men were not approving it. Warren courts viewed as a more liberal court that allowed a lot of criminal rights, some Miranda rights, other things like that. Excuse me. The Burger Court had Roe v. Wade, and then the Rehnquist Court has been seen as a more conservative court. So the 9 old men. Conservatives on the court didn't want the federal intervention into the economy that was happening under the New Deal legislation. And so FDR said, well, fine, we have control over the size of the Supreme Court, so I'm just going to expand it. But Congress refused to do that. And then all of a sudden, as a result of all this, the Supreme Court started upholding the legislation. So it was a very close vote in Congress about whether to expand it. And Congress said no to it. It didn't happen. But then also the Supreme Court started approving a lot of the New Deal legislation and started, instead of striking it down, because it was kind of preventing Roosevelt from implementing anything he wanted to do. The Warren Court, Brown v. Board, which ended segregation, was one of the first cases, expanded the rights of the defendants, knocked down school prayer, just a very active court, which had a lot of decisions that controversial at the time. Some of them are still controversial, but a lot of the rights of defendants were established during this time. Burger Court, generally viewed as a more conservative court from Warren, as opposed to the Warren Court, but had Roe v. Wade, upheld affirmative action, and was around for the Watergate tapes, right? They made Nixon turn over the tapes. Rehnquist and Roberts courts. So Rehnquist was we saw was the justice in Morrison and Lopez on the Commerce Clause, and then was also was also Chief Justice when Bush v. Gore was decided. Then John Roberts became Chief Justice in 2005, and has been seen as more of an activist conservative court, with striking down the rules against campaign finance through Citizens United. But then also we've got the Obamacare Affordable Care Act case where that was upheld. So a lot of people have a problem with activist judges, and because judges are not voted on, right? They're appointed by the president, confirmed by the Senate, and they stay in there for a very long time, right? So they're not very democratic. And so groups, however, and everybody can use the courts to push their agenda. So a lot of times what you see is if there is not success in the legislative area, right, you can't get any laws passed, then groups will often use the courts to try to force a policy process through, hoping that they can find a justice or judge somewhere that will agree with their policy view and then start to write decisions approving it. So they're likely to use the courts when other methods have fallen apart. So some of the issues, kind of what courts should do, right? Judicial restraint is the idea that judges should just not play a policy-making role. They shouldn't see their job. They should just be interpreting cases, implementing the law from before, and let the Congress and the legislative branch change policies, right? Judicial activism argues that judges should make policy decisions. Obviously, no one would disagree now with the idea that we should end desegregation, that civil rights should be promoted, all those kind of things. Well, the court had to do a lot of those things and did them earlier than would have happened through the Congress because of the voting power of the South in the civil rights era. The Congress could have stalemated and not seen any kind of civil rights action come through till much later. Lyndon Johnson in the late 60s is the one who passed a lot of civil rights legislation. Well, Brown v. Board is in 1954, 15 years before all of that. So the courts kind of got there a lot quicker than the Congress could have. And then the question is, well, is that okay or not? And some people say, well, it's okay for racism because we think racism is bad now, but we don't like it for other areas that we disagree with. And it's a little bit inconsistent there, right? There's the doctrine of political questions, where a court can just say, hey, the question before us is too political, and so we're going to avoid deciding that case. And then statutory construction. You know, courts have to interpret statutes to see if they're constitutional or not. That's part of their job, as established with Marbury versus Madison. So this shows kind of some rulings and how many statutes have been overturned during the period as being unconstitutional. And as you can see, there's been a greater tendency, particularly kind of in the last 30 to 40 years here, to overrule congressional statutes, whereas before, like from 1941 to 52, only 3 of them were found to be unconstitutional. Now, we have a lot more that are happening. In judicial decision making, we kind of talk about it in 2 different ways. That while our judges really making decisions just based on their own political views, or are they really looking at cases? How are they deciding cases? And one of the models that is out there is called the attitudinal model, meaning that we can figure out and accurately guess how a justice is going to vote based on their prior votes, right? Because we can determine what the judge's ideology is, and then look at how that ideology matches up with the case itself, and we're pretty good at predicting how a Supreme Court justice is going to vote. So really it's just the judges. This sees the judges as just implementing their own ideology into decisions. The legal model, on the other hand, is a different model, where it sees the judges as putting the personal preferences to the side and deciding things more in light of precedent rather than just their own ideology. However, at some point people have pointed out that plain meaning, the original intent of the framers, is hard to figure out, and precedent can be used on multiple different ways.